So welcome this evening. I appreciate everybody coming out and hanging out with us and sitting in on tonight's presentation, which is titled Different Copyrights, Different Revenue Streams, Navigating and Understanding the Differences. I'm Bill Lord. I'm the founder and executive director of the Global Z Recording Project. Tonight we have one of our board members and general counsel, Mr. James Connell, and in addition to Jay being an attorney, he also has a master's degree in music business from Berklee College of Music, correct? So without hesitation, before I turn it over to Jay, I do want to thank Frederick Arts Council as well as Frederick YMCA as both being sponsors of this event, and also a special nod of thanks to Lucy Kavanaugh, who's running sound for us tonight. So Jay, if you want to take it away.
Thank you so much. All right, so this talk has a complicated name, but it really ought to be called, as an independent artist, how do you get paid? Music is more democratized now than it ever has been, in the sense that it's easier for people to get their music heard. It's less democratized in the sense that it's more difficult to make a living as a middle-of-the-road musician than it was in prior times. We can thank streaming and the streaming structures for that, but it's, as we'll talk about later, it's not really the fault of the individual streaming companies. It's really the fault of the legal structure around that. So we're going to talk tonight about the different copyrights, the exclusive rights that come along with copyrights, and then the revenue streams which come along with those exclusive rights. Before I get too deep into that, I want to make clear that you are not my clients and I'm not giving you legal advice. I'll give you my best understanding of general topics and answer any questions. In that sense, feel free to ask any questions as we go along, because there's no reason to wait on to the end. I'd rather talk about what you want to talk about. So we're going to use as an example tonight the song Fast Car written by Tracy Chapman, and the song is really well known, great hook, and dozens of versions of it have been done over time as covers, but of course the biggest and most recent and most lucrative was Luke Combs' cover that was done about a year and a half ago. The important part of the name of this is the revenue streams, as I mentioned. And so what we're going to do is we're going to use Tracy Chapman's Fast Car as an example of how money flows through different copyrights. So there are two main copyrights that you have to know about if you make music. The first of those is the composition copyright, right? You can do one of two things. You can do them both. You can write music or you can perform music. Those are the two main things that musicians do. And one of the problems, reason why the music industry is so confusing is that everything has at least three names. So this gets called the composition. It gets called, if we were looking at the statute, it'd be called the non-dramatic musical work, right? And of course, it's also in the industry called publishing. Who's getting publishing on the song? So the composition copyright has a couple of different elements to it. One of them is, of course, the words. So if you think about the words to Fast Car, if you just have the text, Tracy Chapman, the sole writer of Fast Car, owns a compositional copyright, a non-dramatic musical work copyright in the lyrics. She also owns it in the music, right? Famous hook, very traditional hook. Everybody who hears Fast Car hears the hook. Interestingly, the licensing on the Wi-Fi here won't let me play the song in my PowerPoint, so I'm just going to clip over real quick and play Fast Car for you, just so everybody knows this hook, probably, but
Remember when we were driving in your
chorus.
car, speed so fast I felt like I was drunk. City lights day out before us, and your arm felt nice wrapped around my shoulder, and I
All right. Interestingly, that song has been covered dozens and dozens of times. We're going to talk about the most famous and most lucrative cover that was recently done. But Tracy Chapman owns copyright, and we're going to talk about her as an individual, then we're going to talk about publishing companies. But she as an individual owns the compositional copyright in that. If you write a song, you own the compositional copyright. Now, I've run into the situation, in fact, I'm working on a case right now where the person who filled out the paperwork and was the copyright claimant who sent the stuff into the Copyright Office was the producer. So they put their name down as the copyright claimant. If you are the author, if you are the person who writes a song, you need to make sure that your name appears not just under author, as you wrote the music, you wrote the lyrics, you wrote both, whatever, but also under copyright claimant. This comes up a lot when you're a person who is writing, multiple people writing together. Brennan and I just got back from Nashville. The Nashville model is 3 writers on a song. California model might be 25 writers on a song, but there are a lot of people who participate on songs. So that's the first copyright, is compositional copyright. Second copyright is the, yes, Mike.
Yeah, put a pin back in that for the claimant.
Yeah.
What is the advantage to being the claimant when you're the claimant?
If you're the claimant, you're the person who owns the property interest in the copyright. You're the person.
The author and the claimant is different.
Then, well, if you are the author and the claimant is different, then what is the rules for the copyright require that you, the claimant, list how you came to acquire your ownership right. So let's take publishing company, for example, right? If I'm a publishing company and you're an author, you write a song, we have a deal, I pay you a certain amount of money, you assign me 50% of the copyright. So at that point, I'm a copyright claimant as the publishing company, and when we get to Tracy Chapman, you'll see her copyright claimants. So you're supposed to explain, if you're not the author but you own the copyright, you're supposed to explain, I bought it, I negotiated it, I traded it for a used car, or whatever it was that happened. All right, sure. Now, let's talk about the copyright in the sound recording. The copyright in the sound recording has an entirely different set of rights that attach to it, has an entirely different set of revenue flows. And so I mentioned there are dozens of recordings of fast car covers of it, but the most famous one is Luke Combs that came out in 2023.
So I remember when we were driving in your car, speed so fast I felt like I was drunk. City lights lay out before us, and your arm felt nice wrapped around my shoulder, and I had a feeling that I belonged. I had a feeling I could be someone, be someone, be someone.
All right. So Luke Combs, more particularly his label, and we're going to talk about his label in a minute, but Luke Combs and his, and people who are attached to him own a copyright only in that sound recording that we just heard. And a bunch of other sound recordings of it too, but that was the official version. So he owns exactly 0 copyright in the underlying words and the underlying composition. Only the performance of it, the sound recording of it, is what he owns an interest in. Oh, sorry.
So remember when we were driving.
Now it works? All right, come on. All right, so 2 different kinds of copyrights, compositional and sound recording. What does that get you? What if you have a compositional or a sound recording copyright, what does that give you the right to do? In the Copyright Act, there are 6 different rights that you own. And they kind of overlap and they get a little bit confusing. So I want to explain them because these rights are going to explain how you get paid for different things. So first is the right to copy, sometimes called the right to copy or distribute the music. That's the one that you think of. That's the right to put it on a CD and sell it. More these days, to put it on vinyl and sell it, to give it to Apple Music to sell for a price, to put it on Bandcamp to be sold, that's the one thing that everybody thinks about is the right to copy. Then there's the right to adapt. And the It's a little bit different for music than for other things, but in general, if you are the author of a work, you control who gets to adapt it. We're going to talk about covers, or we can talk about covers, but let's say that you wrote a book. Let's take it out of the music context for a second, and somebody wants to make it into a movie. As the author of that book, if you own, or your publishing company, whoever owns the copyright has the right to adapt. And as an example of an adaptation, I found what may be the worst cover of Fast Car out of all the hundreds of them.
You got a fast car. I wanna take it to anywhere. Maybe we can make a deal. Maybe together we can get somewhere. Any place is better. Starting from zero, got nothing to lose.
I'm just going to wait till we get to the chorus.
Make something. But me, myself, I got nothing to prove.
You got a fast car.
Oh.
I got a plan to get us out of here. I've been working at a convenience store.
I thought that perhaps that was a spoof. I'm not really sure. But that's the right to adapt. Now, Bill, I want to answer your question now. Bill asked the question earlier, what did Tracy Chapman think about Luke Combs' cover? And we know, because we're going to get to the right to perform in a second, but with music in the United States, anyone can cover any other song. Right? There are a couple of limitations on that. The first is you either need the author's permission, the person who owns the compositional copyright, or you have to go through a statutory notice provision. There's a way that if you don't, like, I'm never going to get to Tracy Chapman, she's never going to talk to me. I doubt sick pay there got permission from Tracy Chapman in particular. And in that situation, there's a statutory notice that you can give. So you can cover any song you want to, and you don't need the original author's permission if you give the statutory notice. But in this situation, Tracy Chapman or her individually owned publishing company, which she owned, Purple Rabbit, which she owns herself, owns 100% of the rights in the composition, which means that she controls the right to adapt it. If you think about it, if you wrote a book, you can't just make a movie out of it and give a statutory notice. That's specific to music, the only time that it works there. All right, the third right you own is the right to sell the music. We see that most these days, a lot of music now is no longer sold, right? Because streaming doesn't sell anything. But if you buy it on Apple Music for $2.29 or whatever the price is, then that's being sold. On Bandcamp, for example, you can, I paid $1 to sick pay for Fast Car. They must be excited because they got an email saying, you got $1, somebody paid $1 for your song. And I have paid. I now own some limited rights in that song. And in this situation, Elektra, which is a label that no longer exists, owned the right to sell Tracy Chapman's music, her original recording of Fast Car. Now, what typical industry standard, the way that it normally happens if you have a label, whether that's one of the big three labels or one of their imprints or a tiny little label, which is what I deal with more often, and typically that in the contract, if you're a musician, in the contract, you sell your entire right to sell, you give it to the label, and the label owns 100% of the right to sell. So often on a sound recording, the copyright claimant, going back to your question, the copyright claimant is the label, and that they pay you 16% of the sound royalties that they obtain. Why 16%? I don't know. But 16% is the industry standard. If you're, Lady Gaga or somebody, you could try to negotiate for more. If it's your first ever time and you're desperate to have anybody listen to your music, you might negotiate away but 16% is the industry standard. And then, of course, there's the right to perform, or meaning the right to perform publicly. As I can't really bring it up big, but I'm just going to play. This is at the Grammys. Sorry. The that is Tracy Chapman and Luke Combs performing together. That could only be done with Tracy Chapman's permission because Tracy Chapman is the 100% owner of the right to perform for her music. So I don't know how the licensing on that worked. I don't know if she was just happy to be on the stage and didn't charge anything extra. I don't know if she got a big payday out of it. I don't know, but she owned that. And she had the right to control whether anyone else gets to publicly perform her music. Now, typically, you issue a general license to the public to perform your music. If you write a song, you want people to play it, so you get with a performing rights organization and you license out that ability. But that is done by contract, right? You own that. And if I wrote this song, and it was so special to me that I didn't want anyone ever to perform it, then I would have the right to say, you don't get to perform my music, or you get to perform it only for $1 million. Brennan.
This is a slightly different question, but it's about the, you said there's three, but there's the two. There's the arrangement one, and then the audio, correct? So what happens if, say, you write lyrics, you share them somewhere, someone else goes to the Copyright Office and registers your lyrics under their name, but then you have the audio thing, and so you register that, but you don't, they register the lyrics before you get to them? Who owns copyright over what?
Wow, interesting question. Okay, so this is in the compositional copyright space. What if somebody steals your lyrics is the question. And these are not lyrics that are in the public domain. These are not lyrics that are so generic that anyone could have written them. They're your specific lyrics. You wrote a poem, for example. And so the way that copyright works is that the original author of a work, whether that be a poem or anything else, is the owner, the common law owner of the copyright. However, registering a copyright creates a rebuttable presumption that you were the author. Okay, so it's not just a race to the courthouse. You could go and have a fight about, I wrote this first, and then they stole my lyrics and they set it to music, and then they made a song and they're not paying me for it. As the author in that situation, if you could prove that happpened, like they used to tell people to, when you wrote a poem or a book or whatever, to put it in a sealed envelope and mail it to yourself, so you had a postal date that told you when you had created the thing to prove that you created it first. So the answer is yes, you are the original author, owns the copyright, but if somebody registers it, then it's way easier for them to claim the copyright than you. So copyright your material if you can. You can copyright it all at one time, right? You don't have to pay the individual fees for each individual thing. There's a way to copyright things in bulk.
So does the same thing apply if you co-write something? Or maybe not co-write, but you have a collaborator in the writing process who decides to take that, and they technically were involved, but that wasn't their idea.
Yeah, that's exactly right. What if, so at the beginning I gave the example of what if the producer, who put the beats under the song or whatever, they're the ones who fill out the paperwork, because let's face it, right? Musicians are not that interested in filling out paperwork, and other people are. The situation is still the same. The author or the co-authors are the owners of the copyright, but it's a whole lot easier for a person who is the copyright claimant to get paid because they have a piece of paper saying it's their copyright than the original author. Yeah.
Question, do you have to be 18 to copyright your original songs and composition?
That's a great question. My guess is no. I'll tell you what, I can look up the answer and I'll give you my email. If you email me, I'll give you the answer. I haven't come across that. You do have to be 18 to enter into a contract, so you would definitely have to be 18. Think Taylor Swift, right, when she's 17. She has a guardian, somebody who works with her who does the negotiation. But I do think that under 18 you could still own the copyright. But I'm going to double check that and get back to you because I haven't come across that particular thing before. All right, so let's talk about the last two Any more questions on that? Because the last two rights, yeah.
What about someone who's younger than 18, but they're a producer for the song?
All right. So typically what happens is there's a contract between the performer and the producer. All right. Industry standard is, remember I said there were 16 points, 16%. Industry standard is 4% would go to the producer. You can negotiate something different, especially if you're paying up front. But if the producer's, doing a lot of work on the song, industry standard is they get 4 of the artist's 16 points. That relationship between the producer and the artist is purely governed by contract. I've seen it. I'm going to pay $2,500 to the producer and they're going to get 0 points. I'm going to assign 4 more. I enter a contractual relationship to assign 4 more points by a letter of direction to the, which says, hey, you all pay them for 25% of my money. And in order to enter a contract, you have to be 18. So typically the contract would be between whoever's acting on behalf of the artist, of an underage artist, and underage artist, and the producer. So, as you might expect, there's a vast amount of law on what happens if you're under 18 and you do enter a contract. And really that's way beyond what we can do here today. But in general, if an artist if anybody who is under 18 enters a contract, they can get out of it. That's generally, contracts by minors are what they call voidable, meaning that you can get out of it, but you might not want to get out of it, right? Maybe nobody ever raises the issue that somebody was under 18 because everybody's happy with the results of the contract.
Copyright Office says that minors may claim copyright, but the state laws may regulate the business dealings involving copyright owned by minors.
That makes perfect sense. That's what I expected the answer to be. That you can enter a copyright, but the contracts around the copyright, who you're selling the copyright to, contract with the producer, contract with the label, etc., are governed by state law, which is that in general, people don't want to enter contracts with minors because they could walk away from it at any time because it's voidable. Okay. All right. So the right to display publicly is another right that you own. It doesn't come up that much in music. The place that it comes up in karaoke, because you have karaoke is like its own subgenre of copyright law because so much stuff happens around karaoke because they're adaptations, because you're displaying the words publicly, because they normally don't get money, right? They're not making money, so it's difficult to handle the copyrights. But that is the right to display publicly. And then the newest right that got added to this, to the statute, is the right to digital audio transmission. Obviously, you can think of that comes into play with streaming, but the other place that it comes into play, which has a whole different revenue stream that we're going to talk about, is with respect to what I call internet radio, what Congress would call non-interactive digital transmission, which means on Spotify, if I want to listen to Fast Car, I type in Fast Car and it goes to Fast Car and it plays for me. That's you get paid one way for that. On the other hand, if it's on Pandora or iHeartRadio streaming or something else, a terrestrial radio station that has an online component, that's digital audio transmission, and that has a different way that you get paid. All right, so there's one more on right that is not listed on here that everyone is super interested in. Sorry, I keep starting that. And I'm going to come back to it, but that is sync rights, right? What is the one remaining big payday in music for your small artist? And that is sync rights. And that is, what if Netflix takes your song and decides to put it in its next show? And interestingly, the statute has not caught up with that at all. So right now, essentially all sync rights are done on a contractual basis, which is the music supervisor for Netflix or whatever the show is makes a deal with somebody. Now, there are a bunch of intermediaries who handle that. I'll tell you that I've seen a whole bunch of people who have come to me and talked about, hey, somebody wants to be my agent and they're going to get me $300,000 because they're in LA. And I have not seen any of those that have turned into anything. They've all been ripoffs, in my opinion, and I've told the artist that. But you know, there are marketplaces where you can put your music out there and hope their music supervisor picks it up. Or you can reach out to the music supervisor specifically and pitch them on your song. And we're going to come back to that in just a second. All right. Now, we've talked about this so far as if you, as an individual artist, own your copyrights. Mostly, you don't, because mostly you sell them to somebody else. And for the compositional copyright, that is generally a publishing company. And I thought it was super interesting when I was researching what Tracy Chapman did. And let's be honest, Tracy Chapman was doing this in the 80s, much different music landscape than it is today. But I thought this was interesting and might be useful to some people. So on the left-hand side is that this is from the copyright database. If you want to see who owns the copyright to any song in the world, or any song in the United States at least, you can just go to copyright.gov and look at their database. There's not even a subscription or a login or anything in it. And it's super interesting to see who owns the copyrights to some of these things. I like looking up the Beatles songs because they're all divvied out to different people. But this was super interesting that I learned that Tracy Chapman in 1987, before the release of Fast Car in 1988, before she had a publishing company, before she had anything, copyrighted her song. She knew she was onto something, and she copyrighted her song as an unpublished work, meaning I haven't released it to anybody. So if you see the number, the registration number on the right-hand side of, well, I guess it's left as you look at it. On the left-hand side of the slide, you'll see that there's a number that begins with PAU. PA stands for Performing Arts. It's kind of a generic for, hey, I've done a non-dramatic work. And then the U means unpublished, means I haven't sent this to anybody yet. So she claimed her copyright. She staked her claim in this song even before she had a publishing company or anything else, which I thought was really smart. I haven't seen that often, but because these days people rush to, get their songs out on Spotify as fast as they can for obvious reasons. But she was like, I have this thing and I'm going to hang on to it until I can shop it around. Then, if you look, yeah.
Where did she publish it? Where did she publish that?
So in the unpublished, right.
Where does that occur?
She submits in this case, it was a cassette, okay. Right? She sent a cassette to the Copyright Office. That demo cassette to the song to the Copyright Office, right? And when you think about older songs, right? Sometimes they sent lead sheets, they sent, scribble scrabble on the back of a napkin. I mean, sometimes they call it the deposit copy. Sometimes the deposit copy is a total mess if you're dealing with an older song. But these days, of course, you would just take your demo, export it, and send it to the Copyright Office. But she did a physical cassette. Yep.
What's the Copyright Office?
So the Library of Congress, everybody has heard of that. It has a thing within it called the Copyright Office, and the registrar of the copyright is in charge of it, and the Copyright Office is in charge of basically everything copyright in the United States, and it's just copyright.gov. If you want to read about it, you just go to copyright.gov. You can read all about it. They tell you all their services. They're very transparent. You don't even need a lawyer. It's basically just easy to fill out forms, and it has instructions on the forms.
You have to pay to copyright.
You do have to pay, right? There's a fee, and it depends on how you can do like an entire album at one time. I was just looking at the amount. So it is in the $50 to $100 range. So I was just looking up the fees for a client, and the fee to get a copy of their copyright was $55. To do a supplemental copyright was $100. So it's not nothing, but it's not thousands of dollars either. So, and you don't have to like piece it out. You can do the sound recording at the same time that you do the composition, right? The two different rights that we talked about, you can do them at the same time. You can do an entire album at one time. And just like if you were writing a book and you had a bunch of pictures in it, you could do all the pictures at one time. So there are ways to make it cheaper, but it's not nothing.
So
and you might have already said this, but I might have missed it. Basically, if you were talking about getting the copyright before you publish it, like if you are to publish it before you get the copyright, does that make you the owner by common law? Even though
Yes.
you don't- Okay.
Yes, that's exactly right. And, if you put it up on Spotify before you get your copyright, it's fairly easy for you to prove where it came from because you have a nice digital record. But if you think about the 70s, right, no, it was just the Wild West and nobody knew who owned anything. Right. So, and people were ripping each other off, and just like now. Yes.
Is there a disadvantage, let's say you have an album of 10 songs, is there any disadvantage if you copyright the whole album versus doing them as individual?
No. If I have a client who copyrighted an entire album and didn't list out the songs, so we had to go get a copy of the old album to prove what songs were on there. But nowadays, if you're filling out the form, you would say, all right, I have 10 songs on my album. Here's the first one, second one, third one, fourth one. But older stuff, not so much. So as long as you have a good record, right, what you're trying to do is prove this is mine. As long as you have a good record of that, then you're okay.
If you push something out on Spotify, should you copyright it first?
Yes.
Yes.
But you also get the codes, right, like the specific,
You get the song codes, you mean?
with the distribution.
Yes. And we're going to,
Specific identifiers.
that's right. You'll have specific identifiers. And we'll talk about the distributors in a minute.
What happens if you post it on YouTube?
Well, what happens?
Someone rips it.
If someone rips it, you have a big fight over who did it first. Was it really yours? What if they rip it and they change it a little bit? I mean, the best thing to do is to copyright your music before sharing it. That's right. That is the best thing to do. Or contemporaneously, right? You can send in the copyright application. It takes a while for them to get it back to you. You've registered your copyright when you send it in. As long as it doesn't get bounced for you didn't fill out the form right or something. But the best practice is absolutely, and I realize that I'm talking to to artists who don't have a lot of money to be paying on fees and stuff like that. But absolutely, the best practice is to copyright it first. And if your song becomes a big hit, it goes viral on TikTok or something, then you're going to wish that you had copyrighted it.
How many years does that protect your rights these days?
A long, long time.
70 years?
Yeah, 70 years. After the, right, yes, that's right. It is a long time. I've never had an end of life issue on those. It's a long time. Yes, that's right. And they keep increasing it. And there's some, there were some times when, the sound recording right didn't come into existence until 1971. And so there's all this stuff that happened to these, what about Elvis songs, right? Elvis recordings.
Sorry, young child, gotta get.
Absolutely. Well, listen, thank you so much. Yeah, of course. Yeah, great. Good luck. Yes.
So you were saying, not copyrighting it if it were to get like big on TikTok. Why would that be an issue? Oh, because of royalties. Is that what you're saying?
Well, so if you go through a distributor, say DistroKid, who puts your song on a variety of platforms, right? And that's what the distributors do. Spotify will not take a song from me, Jay Connell. Jay Connell cannot send in a song to Spotify. I need a distributor for doing that. And so these days, there's a fairly good digital record of where that it got to. But if you want to sue somebody, hey, they ripped my song, then the number one thing you're going to have to do is produce your certificate of copyright. In fact, if you want, there's now a small claims court for copyright, and if you want, you get much better situation there if you can produce a certificate of copyright. Then you get higher damages and everything else than if you just said, "Hey, I'm the common law author of that."
Even though you have like the evidence, like say,
Yep.
Like you recorded it yourself. You
Yep.
have the tracks. Like,
Yep. I mean,
saying having that piece of paper like of that copyright will give you an advantage.
absolutely, absolutely, it absolutely gives you an advantage. Metadata gets lost and everything else. I mean, I'll tell you that dealing with a situation where there's a fight on actually, I'm gonna bracket that for a second. And I'm gonna come back to that and tell you about it when we get to how the revenue streams happen. All right, let's come to labels, because publishing company by industry standard would buy 50% of your copyright, your compositional copyright. Label by industry standard would buy 100% of your sound recording copyright. They own it, and then they send you royalties after withholding for a whole bunch of things. As it happens, there are there are three big publishers and there are three big labels. And Elektra, who was Tracy Chapman's label back in 1988, after a number of changes wound up as one of the big three, Warner Music Group. And Luke Combs, his label is Columbia Nashville, which is part of Sony Music. So their sound recordings are all owned by major labels who handle basically everything that a distributor does for a small artist. They do the distribution, they do the promotion, they do all the stuff, and they hire the lawyers, they do all the things. But in general, the label will own 100%. If you have a label, they will own 100% of your sound recording. That is why you might negotiate for the ability to buy them back. We all know about Taylor Swift and Taylor's versions. Nowadays, all label contracts include a non-re-recording clause so that you can't just re-record your music, get your own sound recording copyright. And now, of course, Taylor Swift has bought back her originals, so they're all Taylor's versions now. But that's how it goes.
Wasn't there just a recent judgment where, like, Kool and the Gang could buy their masters back or got their masters back?
Yes.
Allowed to.
Yes, that's right. There's a sunset clause now where artists, after a certain amount of time, it's a long time, can buy back their masters.
My understanding is if an artist or a group, if they remaster their song, somehow that changes.
Depends on what their contract said. So that did matter for Taylor. She had a huge court battle about it. But for Taylor Swift, she re-recorded her songs, and I was driving behind a car the other day that had a bumper sticker that said, "In this car, we listen to Taylor's version." That was a big thing. Most artists can't do that. First of all, they don't have the money to re-record and remaster everything. But nowadays, there are contract provisions that prevent you from doing that in general. That's all a contract question. What does the contract say? All right, now I want to talk about the other payday that we talked about, which is sync licensing. So I want to give an example of sync licensing for Fast Car.
You got a fast car. I want a ticket to anywhere. Maybe we make a deal. Maybe together we can get somewhere. Any place is better.
Marnie, can you
Start
stop?
from zero, got nothing to lose. Maybe we'll make something. Me, myself, I got nothing to prove.
All right, that was the last episode of Girls, where there was a sync license paid to Tracy Chapman and to Warner for the use of Fast Car. And this was like everything as far as syncing, right? You have the actual song playing in the show. You have somebody singing over it, which is a separate use of the compositional copyright because this actress is singing the song. And so Tracy Chapman has negotiation for that as well as for use of the song. And you have she probably got extra because somebody interrupted her song, right? Somebody's talking over her song, and an artist might, in many situations, say that they want extra for that. So in this situation, one of the reasons why there are big companies who handle sync licensing for the filmmakers is because in this situation, it's relatively small. You have Warner, who owns the sound recording copyright. You have Tracy Chapman, who owns the the compositional copyright for both the actress singing and for the use of the song. So you only have two people to negotiate with. But if the song had been split up and sold and resold, you might have 10 different people you had to negotiate with, which is why it's super hard to do this sync licensing, and it's why people get paid a substantial amount of money to handle that. All right, now getting to the actual royalties. I'm going to take a drink of water here, and let's talk about how do these different rights that we've talked about intersect with the way that people get paid. All right, so remember we talked about there are two different royalties. There's the compositional royalty, owned by the songwriter and the publisher, and there's sound recording, owned by the label, or in some cases, the artist. Let's talk about the songwriter publishing, the compositional royalties first. So there are three major royalties, and they all get paid slightly different ways. So first one we just talked about, which is sync, and that is a pure contract deal between copyright owner and filmmaker. Those are often negotiated by the labels, right? Labels make a lot of money on that, so so they do that work. And then second one is the mechanical royalty. The mechanical royalty is the royalty paid for taking the song itself, the composition, and recording it or doing something with it. The reason why the phrase mechanical royalty makes no sense at all, and it comes from the time of player pianos, because in the late 1800s, the way that people made money was that they wrote music, and then these player piano people came along and started, turning that into something that a piano could play. And the songwriters were mad because they weren't making any money off of that, and the law didn't cover it at the time. So that's called a mechanical royalty, because at the time, literally, it was mechanical. All right, so those are, if you're one of the big three labels, those are generally not handled through these public mechanisms. They are negotiated directly by the labels. But let's move off of that. Now, what about, now we have to divide the world into streaming and non-streaming. So the most important one for most small artists is streaming. And that changed relatively recently. About 5 years ago, a new law came into effect and created a thing called the Mechanical Licensing Collective. And it's themlc.com. And the Mechanical Licensing Collective is the way that mechanical royalties get paid by streaming services. Now, before 2020, if Spotify, Mechanical Licensing Collective. It's the, T-H-E, no, T-H, the. Yeah, the MLC.com. Yeah. And back in the day, it was really hard for Spotify or somebody to pay small artists, right? Because first of all, the artist might be recording, they might have written it under the name Fred with a PH, and
I wrote that piece.
yes, exactly. There you go. And but how do you find Fred to pay him? It's kind of tough. But now everybody goes and registers with the Mechanical Licensing Collective. So you want to if you don't have one and you're an artist, you want to make sure that you start an account on the MLC and that you make sure all your stuff is up to date, including, hey, I wrote 50% of that song, or I wrote 6.5% of that song, or I wrote 100% of that song, whatever it is, because that's how the very small amount of money, the micro pennies that flow from Spotify, they flow first to the Mechanical Licensing Collective if you don't have a label, and then they flow to you. For non-streaming, there are other ways to do it. The biggest one is the Harry Fox Agency, which in general handles the distribution on non-streaming mechanical licensing. So if your song is big enough that somebody might want to do a cover of it, for example, you register with Harry Fox Agency and they pay it out that way. That's also how, as a small artist, if you want to do a cover of somebody else's song, you can go buy a limited license on Harry Fox Agency. It's quite reasonable. You just go and you pay them the small amount of money, and then you can distribute 2,500 downloads of it, or however many you decide to pay for. Now, the last one is public performance. And when people talk about that, some people earlier were saying that songwriters So yeah, that songwriting is the more lucrative of this. That's because of the public performance right. The public performance right. There are three major performing rights organizations: ASCAP, BMI, and CSAC. I don't really cover CSAC because that's really for quite established artists. That's a for-profit organization, whereas ASCAP and BMI are really accessible to everybody. There's not any. I've never heard anybody articulate any clear advantage between one or the other. ASCAP is not for profit. BMI is for profit, but they seem to pay the same. And I heard somebody say last week that really, whoever you met first, if you had a friend who was in ASCAP, you generally joined ASCAP. If you had a friend who was in BMI, you generally joined BMI. It's also, the BMI is and ASCAP have joined together for an online tool called SongView. That's really good. If you're interested in figuring out who owns who gets paid on any particular song, you can just look it up on SongView. I had a situation where somebody wanted to know if anybody was claiming rights to their song that they had written, and sure enough, you just easily look it up on SongView, and it tells you who gets it. And that's the metadata that you mentioned earlier, which is that most metadata is maintained by one of these other organizations in SongView for ASCAP and BMI, or on the MLC.com for Mechanical Licensing Collective. So if you're a songwriter, you want to make sure that you have all your information up to date in SongView and the MLC. You'll also see on there that it lets you apportion songs, and ideally every song would have 100% of its songwriter royalties apportioned, but sometimes you were a co-writer and the other person didn't fill it in, you claim 50% and that other 50% goes unclaimed. Or sometimes more people claim it than actually, everybody says there were three of us and we each wrote 50% of the song, and you have 150% as an overlap, and then somebody has to work that out. You need to negotiate that down to 100% so the royalties can be paid. All right, so let's move to the royalties in sound recordings. Sync, again, is handled entirely by contracting, and so you might go through an agent or you might get lucky. Then there is what you think of as the core right, the right to copy, the reproduction and distribution of your song. And we've talked a little bit about distributors already. Most small artists work through a distributor like CD Baby or DistroKid or TuneCore, and they handle all of that, right? So as I understand it, and Spotify generally right now pays about 4/1000th of a cent per stream for a song. About 75% of that is for the sound recording copyright. About 25% of it is for the copyright for the composition. The reason why I say it that way is that unlike a vinyl, for example, when a song gets pressed onto vinyl, unless you have negotiated something else, there is a statutory rate set by Congress. The songwriter gets, right now I believe it's 12.7 cents, gets 12.7 cents for each song that is pressed onto vinyl. Spotify works entirely differently. Spotify has to pay a certain percentage of its gross revenue. So there's not, when we say that it's 4/1000th of a cent, that could vary by person. It could vary by what label you have. It could vary by a variety of questions. And then that is also the way that the performing rights organizations work, or very similar to that. They have a very complex way of paying. You cannot predict in advance what, if anything, you're going to get from the performing rights organizations, because it is not the equivalent of 12.7 cents per stream. It depends on what radio station, or what, if it's terrestrial radio, what radio station it was played on, how major a market it is, how heavy rotation it was in, a wide variety of things. Because think about bars have to pay licenses to play music over their speakers, and they just pay a certain license, and then they play whatever ASCAP song they want to. And if their license is $500 a month, somehow that gets divided up among all the different artists that they played. So it's very difficult to predict in advance what's going to happen. But I did just mention terrestrial radio, and it's important to know that in the United States, it's different in other countries, but in the United States, there is no royalty for sound recordings played on the radio. So if a new song is, if Luke Combs' Fast Car is paid, which was at #1 for a number of weeks, if it's played, let's say 1.5 million times on terrestrial radio, there are 0 sound recording royalties paid to anybody for that.
So the label gets nothing.
The label gets nothing,
But the guy who wrote,
but Tracy Chapman does.
gets a 12.5 below no.
Well, no, that's for putting it on a song. But she gets, ASCAP is paying her some substantial amount of money. It has been reported in the press. I don't have any personal knowledge. Reported in the press that she made about $500,000 from the songwriter royalties on Luke Combs' version of that song. Yeah.
So I'm a little confused with that, with the radio and not paying the royalties.
Right.
So so who gets paid and why do they get paid and not other people?
Okay. When a song gets played on terrestrial radio, internet radio is different.
Right.
But terrestrial radio, then think about our two different royalties. On the sound recording royalty, nobody gets paid.
Okay.
Right? The terrestrial radio's argument has always been that we're promoting your song to the public, and they will go and buy your song. And that was true up until the 1990s, and then all that went off the rails, in my humble opinion. But it's still that way today. And terrestrial radio now will say nobody listens to us anyway, so why should we have to pay? So they've really tried to have it both ways. But when a song is played on the radio, the radio station reports to ASCAP and BMI, here are all the songs that I played this month, and ASCAP and BMI run some magic math on it, and for a song that got huge play, like Fast Car, they say, all right, this is how much revenue we took in, this is how much of that revenue was associated with Fast Car, we're going to do some math to that, and we're going to pay the people who own the rights in the compositional copyright.
Okay, so from a radio station, for example, or any of these, this is how much we took in, right? It's not took in by any particular means, right? It's ad revenue, it's combined revenue of what Spotify brings in, it's combined revenue of what W, fill in the blank, brings in, that then is distributed by a guess by someone like TuneSat or a monitoring organization that says it's likely that your stuff was played 1.5% of the time this month.
Yes.
And so they took in $1 million and you're going to get $1,500 or whatever it is.
Yes. We're gonna put, you mentioned Spotify, we're gonna set them aside, right, because they're streaming and they're different. But for terrestrial radio, yes. And the big radio stations actually, report it out, have direct, as you say, have direct data these days. But back in the day, somebody had to listen to the radio or make guesses and do stuff like that. And yes, it is in general the idea is that ASCAP and BMI try to apportion the money that was coming into them for performance rights royalties to make that roughly equal to the amount that they're paying out in a percentage. And so Taylor Swift is going to have a much higher percentage of whatever revenue that ASCAP and BMI, I don't know which one she's on, had, and probably CSAC, and versus you. Right, exactly. But that's the idea. And then last, the sort of...
Yes.
Yeah. The sort of... there's also a thing called neighboring rights. They're more important in other countries than in ours, but the one place that neighboring rights show up in the United States is in what we talked about, internet radio, digital, non-interactive. For example, I have an app that I like to listen to, which is called Radio Garden. It plays the internet versions of every radio station in the world. And if I'm listening to that, I don't get to choose okay, I want to listen to Fast Car right now. I get to choose the station and it comes over. Sound Exchange is responsible for administering the same thing. It's like a performance rights organization, but it's a neighboring rights organization. And it only applies to digital, non-interactive. Okay, now before we close, I have to talk about AI because these days you cannot really talk about music without talking about AI because people have heard that Spotify has reported that 100,000 new songs are uploaded to Spotify each day. And that is because the vast, vast majority of those are made by AI and then played by bots to try to generate revenue. It's a sort of a fraud scheme that's out there. But every new technology that comes along is adapted by artists first, right? Artists love new technology. They love to be on the cutting edge of things, whether we're talking about, the 808 or whether we're talking about AI. And so artists have a lot of brilliant ways to use AI. Randy Travis recently released a song because he can't sing anymore. Huge country artist, but used AI with his involvement to release a song. The Beatles released a song 2 years ago that had all 4 Beatles on it because they took an old recording and used AI to augment the audio and make it good enough to use John Lennon's voice. So AI is huge out there, but at the same time, it has frightened the Copyright Office enormously, and the Copyright Office has never had an AI-friendly published decision. All of their decisions have said that anything created by AI cannot be copyrighted. It is the same as being in the public domain. So even if you make the best song in the world using AI, the current law, and this could change any minute, but the current law is that anything made using AI is not copyrightable. Well, yeah.
Is that any use of any type of AI?
No, it's the AI portion of it. So let's do the easiest one. Let's say that the ChatGPT writes the lyrics and you write the music, right? You can have a copyright interest in the music, but not the lyrics. Now, you can see how that simplistic idea breaks down very quickly because what if you generate the initial beat using an AI, but then you export the stems to yourself and you make a bunch of changes in it. And yes, so that 4 on the floor that's in there, which is super generic anyway, was made by AI, but all the actual beat that you did, that you put in the hi-hats, you put in all the good stuff that made it into a hit song, but that was a human contribution. The basic rule that we know of right now is that all human contributions that are not in public domain or otherwise are copyrightable, and the AI portion is not. So I'm going to answer this question, then I'm going to go back to that.
So like you were saying, you're talking about and this is what I heard, that if you make a beat that's AI and then you have lyrics that are yours, or the other way around, the part that's AI is not you cannot have copyrighted.
That is the short answer. Let me give you a little bit of a longer answer.
Okay.
The longer answer is, here's what we know. First, we know that no matter how complicated your prompts are, no matter how, it could be a 400-word prompt with incredible specificity. And if you've ever used Midjourney, you know that absolutely happens, right? Midjourney which makes pictures, is pretty difficult to use, right? It's not, hey, draw me a cat. It's way more complicated than that. Some of the AI, the music AI that you see that is similar to that. It's very complex, but no matter how complex your prompts are, if AI made the music, you cannot copyright it. Now, what about Randy Travis and John Lennon, right? Those were examples of huge artists using AI. And the way that the Copyright Office dealt with that is that they said, in that situation, AI was an assistive tool. That's the quote, an assistive tool. The AI was not responsible for the creativity. It was just an assistive tool like, a distortion pedal. And so if you can characterize your use of AI, and there are so many of them, if you can characterize your use of AI as an assistive tool, then you could copyright it. Now, we don't have tests for what is an assistive tool. We don't know anything about it yet. But if you can, call it an assistive tool. And
What's the difference between that and sampling, really?
okay, so sampling.
I mean, I know what sampling is, but
No.
derived by, right?
Right.
The way you got Randy Travis's voice is you sampled Randy Travis's voice long enough so that you could make him sing whatever you wanted him to sing via AI.
Right.
Still have to sample it, still have to sample him, don't you have to get a license? In every other instance, if it's not you, and you want to use James Brown's "Hey" on a record, you have to go license "Hey," right?
So, super complicated question. Let me give you. So, first of all, think about our two different copyrights, right? A sample is the sound recording copyright. Okay. So yes, and in every situation, at least in non-de minimis uses, a sample has to be licensed and cleared. Right? What about the situation where, but that's different from the compositional copyright, right? Where AI is writing the lyrics or AI is composing the beat for the first time. And we don't have any cases about what about AI and sound recordings. We don't know yet. So to be honest, we don't really have any idea about how, if it was contested, how that John Lennon recording would be used. Or the fake, the biggest one was fake Drake, right? Somebody uses Drake's voice and a sample of extensive sampling of Drake's voice and makes a song using Drake. The Copyright Office recently suggested that right now there's no protection except by state law, that there's no federal protection at least for the use of voices. So this is wildly, this could be its own presentation, but it's a huge question not resolved yet. But the two other things that I do want to say about AI is one cheap, easy way. We talked about filling out the copyright forms earlier. One cheap, easy way is on the copyright form you say, I disclaim copyright for all AI elements, and then give a brief description of what you did. And whatever's left after you cut out the AI elements, you own a copyright in. And no one's ever going to fight about that unless somebody sues somebody for copyright infringement later. Because then you're going to have, in the same way that now for copyright infringement, you have to say, well, yeah, but that song was really written by Beethoven, or that's one of the 16 most common chord progressions in the world, so nobody can copyright it. You're going to have to, the day will come where somebody's going to have to sort out, here was the human contribution, here was the AI contribution. And then last, this is totally untested, but it's kind of my pet theory. There was a case about phone books. And if you don't know what a phone book is, they used to take all the phone numbers for landlines and put them in a book. And individually, each of those items was not copyrightable because how could somebody's name and phone number be copyrighted? But you put it together, it was a lot of work to put them together into a book, and they would sell the book, and they would sell advertising for the book called Yellow Pages. And the Supreme Court said that the selection and arrangement of uncopyrightable elements could itself become copyrightable. So if you have, there's only a certain number, there's only 12 notes in the Western scale, right? And so in a way, all music is selection and arrangement of uncopyrightable elements. And at some point, it becomes unique enough that we know that it's fast car. So if you have an AI situation, call me because I'd love to talk about it. My master's thesis was on AI in this situation, and it's something that I'm super interested in. So we've had a lot of questions. And we're at the end, but Lucy, let's go back to you.
So the one that you said just before this last bit that you said,
the disclaimer one.
Or about the AI was like, are you? And again, this is just what I heard. Correct me if I'm off, but like I heard you say that maybe, and it isn't this way right now, but maybe one day like there could be like AI is copyrightable in the way that like whoever owns the AI gets the...
No, that's the rule in the UK. All right, so if you're a UK artist, if you're Doja Cat, and you build an AI and you run it. Whoever is responsible for initiating the AI, which means in modern terms putting in the prompts, owns the copyright in UK. The United States and a number of Commonwealth countries, it works that way in India and a few other places. The United States chose not to do that so far, and it may take a different Congress than the one we have now before they can sort out any nuanced issues like these. But the rule in the United States is whatever AI contributed is not copyrightable.
Okay. So I guess that answers part of my question, but I guess I'm confused. So say like whoever owns ChatGPT, or whoever owns Gemini, whoever owns whatever, like they are the people who have created this AI and run this AI.
In the US, they got nothing. Even in UK, they have nothing. They have nothing to, they acquire no copyrights by the fact, if ChatGPT writes the most beautiful song ever written and it sells 1 billion copies and gets 10 billion streams, OpenAI gets nothing.
Yay.
And are you saying that's the way it is now, but do you think that there is a future that could change, or is that not a law that would ever, like, you would think that would come up?
Well, you know, OpenAI may buy and sell us all one day, so they might buy and sell this too. So, yeah, exactly. And you know, once I'm paying my taxes directly to Amazon, that all the changes are going to happen. But the thing that I was saying was, one day the time may come where somebody has to sort out what part of this hit song was written by AI and what part was written by human. And under current law, the AI part would not be the basis for a copyright infringement claim, any more than, you know, anything else in the public domain is not the basis for a copyright infringement claim.
Okay. Yes.
Okay.
Well, that don't dissuade you from using AI to create at least melodic strength, because the next guy can type it in and get the same thing, and you don't own it.
Yep.
Oh.
That's right. Whereas you think about the beats, you know, I'm not sure how many beats are copyrightable anyway. They're right there. I mean, a lot of them sound very, very similar. So
Doesn't
I don't know.
doesn't count if you press a button on the 808 from, right, Dr. Dre takes an 808,
Right.
puts the sequence on it, it's the first thing on it.
Right.
Roland doesn't get a piece of the action.
Exactly right. Exactly. All right, and that's basically it. I think your questions were great. Thanks so much. Super interesting. I hope it was helpful. And my numbers are up there, but feel free to give me a call or send me an email if I can be of any help. Thanks so much.
I have one more that we
Yeah.
avoided,
Okay.
which was YouTube.
Okay.
There's in my particular case,
Yep.
I have a song
Yep.
that I was a work for hire, but
Yep.
that I own I'm still listed as a writer,
Okay.
et cetera, et cetera. It's got 28 million views,
Wow.
right? It's almost potty time. It's one of the most popular of.
Children's music. Yeah. Children's music is the number, I read recently, it's the number 9 largest genre.
Yeah.
I mean, it's huge.
Doing really well.
Yeah.
But in any case, I've never seen a dime from it.
Mm-hmm.
I've written ASCAP and said, how come I haven't seen a dime from it? And they're like, YouTube's not my problem.
Right. So do you own part of the copyright?
I own, as the writer of the music, yes. Am I a claimant? No.
All right.
I have the right as public performer, as part of composition.
Right. I say that because you mentioned work for hire, and you know we could talk. But if it really was a work for hire, then somebody bought the.
Within the contract itself, it says you have the right to collect your.
Okay, sure. Yeah. So they bought some of your rights and not others.
Yes, and
Yes.
for them, they want to, they hustle it because they want to make their money too. I mean,
Right.
They copyright.
And that brings the. That means that you have to work contractually through the contractual structures with YouTube, which means essentially a copyright strike. And the way that you initiate all copyright disputes with YouTube, hey, somebody stole my song and they're doing a dance to it or whatever, is you file a copyright strike. Yeah, and that starts a process which can get elevated up and up and up, depending on, this sounds like a very substantial claim. But it all gets litigated essentially by our, Google corporate overlords within their little system of contract management.
And within that, there's, Sesame Workshop owns the copyright on
Sure.
the actual video, et cetera, et cetera.
Right.
So I wouldn't know.
So you have pieces of the right.
Yeah. I don't know that you'd want to, if I form a strike, then I'm affecting my relationship with Sesame. Only Sesame wants, it's only if the publisher wants to go at it for you.
Yeah, that's right. And that, which is true in all contractual situations, right? Sometimes you want to get paid right now, and sometimes you want to remain in the running for the next contract.
Yeah, exactly.
All right.
That 23 million.
I can imagine. All right. Well, thank you all very much.
Thank you.